Good evening, everybody, and welcome to Adapting to Remote Virtual Litigation. I'm Barry Chase, the CLE Director at NYCLA, and before we begin, I just have a few announcements. First of all, this program is part of our NYCLA 90210 series of programs, and we're very happy to be doing this with the Beverly Hills Bar Association. Also, it is also part of NYCLA's 3-evening Bridge the Gap program. So we have many different people joining us, and we want to welcome everybody. By next week, you'll receive an email, which will have a link for where you'll be able to download your CLE certificates. Just click on the link, enter your name and email address exactly as you registered for the program, and you'll be able to download your CLE certificates. The link is also in an email that you received from our registrar, Amelia Brzezinski, 30 minutes ago. But if you click on the link now, you're not going to get your certificate because we have to check to make sure everybody stayed and prorate any certificates as necessary. Also, I encourage you to download the CLE materials, which are outstanding. There are over 300 pages of New York and California critical information. And that link is also in your email that Amelia sent out, and it's also in the Zoom invitation that you received to join the program, and we'll also be posting that link in the chat box. Also, at the end of the program, you'll be prompted to complete a survey, and we'd appreciate if you would do so, as we always are interested in any feedback that you can give us. And finally, we are trying to make this program as interactive as possible. So if you do have any questions for our speakers, please type them in the Q&A box, which is on your Zoom toolbar. Please don't put the questions in the chat, as we use that for more general information. And those are all my introductory remarks. And now it'll be my pleasure to introduce our moderator, Hillary Johns from the Beverly Hills Bar Association. She is a trial attorney in California who successfully resolves disputes related to business, employment, and entertainment. She has decades of experience representing individuals and companies in business law and civil litigation. And finally, she's really, really qualified to be the moderator, as she was also recently sworn into the New York Bar. So Hillary, I'm going to turn the program over to you. Thank you.
Thank you, Barry. I so appreciate it. On behalf of the Beverly Hills Bar Association and all us Californians and some of us who are temporary residents in New York, such as myself, we so appreciate working on this program together. And I think we're all going to learn a lot from it today. I know I have been planning it. After the program, please look at the materials. There's a lot of great stuff there, really informational. I think everybody can learn from it. And I wanted to introduce our speakers. So from New York, we have Josh Kelner of Kelner and Kelner, who has a very well established firm in New York that does personal injury and civil rights law, as well as civil litigation. And we have Byrne from Davis Polk, who is a very accomplished trial lawyer and is going to be speaking to us on several subjects today, as well as Gabriel. I'm going to do this right. Jaime-Bettan, who is also with Davis Polk and who does a lot of civil litigation, is a very accomplished lawyer himself. We have from California, we have David Lefkowitz, and David is a super lawyer and does a great job. He is the one who always gives the practical side of law here when we need to hear it. So I think you will enjoy hearing from him, as well as Dan Lapidus of Lapidus and Lapidus, a civil litigation firm here in Beverly Hills. And we have several subjects to talk about, and I know that we usually get a lot of questions during this. So what we're going to try to do during the appropriate times is get to your questions as promptly as we can and towards the end of the program. If at the end of the program your questions haven't been answered, you'll also have the contact information for each of our speakers if you'd like to contact them individually. And I know that all of our speakers are more than willing to do that. And so now, without further ado and any further delay, we are going to get into the wonderful world of depositions, which is what everybody wants to know. And the top 10 tips that David has for us with depositions and how to take remote depositions, what to do, what not to do, and what we recommend. And Mari will also be making from the New York side that part of the presentation as well. David?
Well, thank you very much, Hillary. Thank you, Barry. Thank you to the bar associations that are hosting us. I'm coming to you from Ocean Avenue on Santa Monica, where it's 71 degrees. The sun is still out and the coast is clear. Against that background, I'm going to address what I have called the COVID deposition topic in California. By that, of course, I mean remote depositions. Remote depositions have always been a thing, which we did on occasion, we litigators did on occasion. Somehow, if you could get the other side to agree to it, if you had witnesses like I had once in Nicaragua, it was a great idea to try and put that together, and we were able to do that. But while the trend in litigation over the last decade and a half or so has been electronic, and all the good stuff is in the emails, and there's been a cottage industry of electronic discovery and electronic litigation, we still have done depositions the analog way, where we would fly out to Nowheresville the day before the deposition, stay in a hotel, go depose someone for perhaps an hour, burn 2 or 3 days doing it, and get on with it and not think anything of it. And then COVID happened. And while the virus paralyzed us to move about for a while, the world realized it couldn't stand still. The court dockets were quickly getting congested. Litigators didn't want to put their practices on pause. The clients wanted cases moving forward. Everybody wanted to do litigation. Nobody wanted to be near each other. So remote depositions took over, remote mediations, which I know other people are going to be talking about, remote arbitrations, and of course, remote trial. Now, I have done many multiples of remote depositions this past year than all of my prior 34 years of law practice combined. And just to give a few statistics on this, Esquire Deposition Solutions did a survey in December 2020 of 26,000 litigation professionals. Over the of those people that were lawyers, over 93% of the litigators surveyed conducted remote depositions between May and December 2020. Now, some of the common concerns that have arisen that have made people shy about doing them are virtual management of exhibits, technological failures, outside influence on witnesses, coaching, lack of physical presence to maximize the effectiveness of the questions, and the ability to effectively advise our clients. And I'll get into all of those as sort of built into these 10 points. Among the positives were that the state, on the state level anyway, they're legal. So that's always good news. And they're secure and very convenient. And so what I hope to do is to address some of these points, starting with part one, which is that they are legal in California and they are legal in federal court. The California statute is 2025.310. The federal rule of civil procedure is 30B4. And California has it set forth pretty clearly. The deposition officer doesn't have to be in attendance with the witness, who doesn't have to be in the attendance with the counsel, who doesn't have to be in attendance with opposing counsel, and the attorney, and this is part B of 310, the attorney can be with the witness if the attorney so chooses, but doesn't have to be. Now, and you can just simply notice a deposition now under that statute and directly conduct a remote deposition. It's a little bit different under the federal rules, where a stipulation or court order is required under 30B4. Now, Stipulation is preferable, obviously, but not necessarily always obtainable. So to get a court order, the courts have, there's been some law on this. The courts engage in a two-part inquiry. The first is the party seeking a remote deposition must advance a legitimate reason to do it. And then number two, the burden shifts to the opposing party to make a, quote, particularized showing that remote depositions are prejudicial. If the party opposing the remote depositions can't make a particularized showing, then the court should grant the motion. And this will come as no surprise to everybody. The courts across the nation have recognized pandemic conditions and physical distancing orders related to the current pandemic as legitimate reasons for holding depositions remotely. There's case law out of Nevada. There's actually a case out of New York Supreme Court. That's the Chase Morris versus Tubby, T-U-B-B-Y case. So I would think it would be readily obtainable to get an order like that. But if you can get a stipulation, it's better. And here are some of the things that you might want to consider for stipulations. First of all, you want to set out what platform you're using. You know, obviously, everybody should learn Zoom. It's become as ubiquitous to office life as Word these days. Some of us are still using Word Perfect, I might add. But nevertheless, Zoom seems to be the platform of choice, but there are others: WebEx, Microsoft, Google. There should be a reference to no objections that will be made to use of the remote deposition transcript. There should be, the noticing party should make all of the arrangements, including provided notice of any technology required to participate in the remote means selected. Court reporters can administer the oath remotely. The parties are not required to take the deposition remotely, but if the parties choose to do the deposition in person, there should be room that allows for social distancing, and a mask should be worn. Another point, if a deposition proceeds remotely, nothing should preclude the deponent's counsel from defending the deposition in person, and people should anticipate technology issues, exhibit management issues, and the like. We'll get into a little bit about exhibit management issues, but it's a good idea to cover that in the stipulation as well. One important thing to remember is that not all witnesses and parties are equal when it comes to computer savviness and equipment. Some people are using iPhones. Some people have lousy Wi-Fi. All of that could affect the outcome. And I think it's best to try and suss that out with opposing counsel and with third-party witnesses ahead of time. And again, that's something that you might want to crank into a stipulation. When it comes to California, notices are perfectly legitimate, and you'll probably want to put in the Zoom platform or whatever platform you're using, but you've got to put it in the notice. We have a rule of court here, 3.1010A. The location of the witness and of counsel would be an important thing to include in there. In a 30B4 context, keep in mind that the place where the deponent answers the questions is the place of the deposition. So you want to put that into the stipulation. Document management is something I mentioned briefly earlier. One of the biggest reported concerns by lawyers about doing remote depositions is the management of electronic exhibits. Zoom has a screen share feature, but it's really not built for depositions. So the legal industry and the reporting services have come to establish management features, which you should ask the court reporters about. For instance, they have set up private to public share file folders. so that you can upload your documents confidentially ahead of time. And then after the document is marked, it's pulled up, it's marked, it can be put into a public folder, which is accessible to the witnesses. So you could start it out with being confidential, and then it can be pulled up and then put into a public file with an exhibit number. The way I like to do this, and this is trial and error, is I take the documents that I have for the case and I give them internal numbers, document 1, document 2, document 3. And those are easy as electronic files. I upload those to the private platform. I make one copy for myself and I write the doc number on each copy. And when I take the deposition, I describe the documents with Bates numbers, and then when they're assigned an exhibit number, they become that exhibit. In some ways, this is easier for document management, for preparation especially, because now you don't need to make 4 copies or however many copies you need for every single person in the room, which can be extremely onerous for, I guess, firms that don't have separate departments that are doing that. But nevertheless, it could be extremely onerous, as it has been for many lawyers, to take these big giant piles of large documents into a room. Now all you need is one document saved electronically, your own copy, and then it gets pulled up, and then the witness prints it out or looks at it, and the attorney. So it's, in some ways, it's much easier, but it has to be done. The prep has to be done earlier. So that's the trade-off. The next point I want to make is simply that we should all learn the bells and whistles of the program that you are using. For instance, screen share, that's a good idea to learn, because otherwise you could run the risk of opening up your file and trying to get to it and show everybody that what you're really doing is following the incredible surge that the Dodgers are having in the most recent month of Major League Baseball play. Meaning just close everything out and keep your screen share document up and available, and that'll make life easier and better. Another thing is the picture that you see on the Zoom platform. You want to figure out how to make it larger when you've got a document up on the screen, because it's hard to read a witness when the picture is sort of what I'm looking at now, except for Hillary, which is, a tiny, tiny picture, and it's hard to depose a person that you can barely see. Also look into real-time transmissions. They're available, and look into this double monitor approach that a lot of people like, where they themselves have their deposition outline on one monitor and they have documents on that same monitor, and then on the main monitor they're showing documents and they're looking at the witness. So in some ways it's easier and smoother. The next point is the COVID admonitions, the remote admonitions that you'll want to touch on early on in the process of the deposition. With the rest of the admonitions, is anyone else in the room with you? If anyone else comes into the room, please let me know. Are you looking at anything other than the screen which you're giving the deposition on? Will you please not look at anything else? Answer the questions by yourself. Now, obviously, this is all because of the difficulty that can arise with coaching by a third party. And you really have to be on the lookout for that. One experience I had very briefly was taking a deposition, and all of a sudden I noticed that after one of my more pointed questions, I heard a ping on the witness's phone. And I thought for a second, and first time I think I let it go. And then it kept happening. And finally, I said, are you getting pinged by the other defendant in the case? And I am instructing you now on the record, and I think this is a good thing to do, instruct on the record to save all text messages that are being exchanged between the parties of the case and any third parties during the time of this deposition, and I'm calling for the production of those documents. And I think when you do that, you will shut down any future problems and potentially get some very interesting cross-examination material for that particular witness. And of course, with Zoom, it's tough because it's hard to know when people should talk, because if opposing counsel starts objecting and the witness starts talking and everybody converges, court reporter is going crazy. With the Zoom situation, you have to be very careful with that. The next point is, where is everyone? Who's on the line? This never occurs in an in-person deposition. Everybody knows everybody knows who's in the room. Everybody knows, can see them. Everybody, if a person's not supposed to be in the room, then the person gets kicked out. Well, with Zoom, it's a little bit difficult. It's a little bit more difficult. Some people try to participate and attend where their video is not on. Some people try and participate sub rosa. So you've got this. This raises important issues that have to be addressed. Confidentiality in cases with high-level confidentiality information is particularly a problem. You're going to have protective orders. What if the protective order has an attorney's eyes only provision? What if the protective order has it so that documents cannot be electronically shared or copied electronically? What do you do with a situation where you've got a remote deposition where electronic images are going to be formed of those documents the whole time? So you've got to be careful with that and get ahead of that. The check the protective orders, go over it with opposing counsel. I think you can figure it out, and the court reporter could probably help with the transcript and make sure the transcript is separate and confidential, or a part of it anyway. And if you have a technician working on the platform, I think you'll at least be able to see who's logged in, and beyond that, I think you're going to have to get it, by way of agreement with opposing counsel as to how it's going to be handled. Speaking of the exhibit technician, the next point I have is that documents should be handled with care. I personally like to use the exhibit technicians. They're available through most of the court reporting services. They will put your document up. They'll find it for you. They'll take them down. It just makes things a lot easier. A lot of people like to have their own control, and you can do that too. You can put up your own documents by screen share. But with an exhibit technician, what they'll do is they'll put the document up. When it's marked, they'll circulate it by way of chat that we have here, or by email. It's in most of my cases anyway, we don't want to be sending documents ahead of time. We want the element of surprise, and you can get that with remote depositions. I've already covered the coaching, and I think that it's a very important issue to take care of and make sure you protect yourself. You can get real-time feedback with a remote deposition through by having an iPad sitting next to your computer, and you can get notes from your client if you choose. And of course, the other side of feedback is what you don't want, which is a technological problem. So make sure you're communicating well with the witness, with the court reporter, and with the technicians. Finally, my last point is to turn up the energy. I've talked to people. They find that there's not the same energy that you get from being in a room with all of in the room where it's happening, I guess, so to speak. And you want to try and fight that. Bring the energy and try and stop the, professional athletes had to go through seasons where there were no fans. And I think that they would all say, most all of them would say that deprived them of energy as they were going through their game. I think that, with Zoom, you've got a similar issue. So something to be on the lookout for. So in conclusion, I just want to say this. I think that remote depositions are here to stay and will become common practice. In that same survey I referenced earlier today, a quarter of the respondents said that they would likely take over half of their depositions virtually after the pandemic. More than a quarter said that they would take up to 50% of their depositions virtually. And the question is why? And I think the answers are, we're adapting better. We're getting better at it. It's a huge time saver. And even going to another part of town, at least here in Los Angeles, where we've known to have a little traffic, can be, a full day affair. And then finally, the generational shifts towards technology, which is going on. And so I think it's here to stay. I think it's a good thing. After 35 years, I ask, why didn't we do it more earlier? But I'm happy we're doing it now. Again, thank you, everybody, for the opportunity to present.
Well, David, thank you. And that was all very insightful and I think very true. And I think a lot of us can relate to that. And so next is Mari Byrne from New York. And after Mari concludes her comments, we're going to open up this up to some of the other speakers to share some of their insights as to depositions. So Mari, thank you for coming.
Yeah, thank you for having me. And thank you, David, for all the insight. That was great. I will try to be brief and maybe just touch on a couple of quick points following up on David's. I guess to start, in New York, remote depositions are authorized as well, but also only by stipulation. So the relevant rule under the CPLR is 3113D. And then there's really nothing right now that addresses what happens if you seek to take a remote deposition by motion. So there actually is a committee in New York that's been pushing for there to be a new rule that addresses that going forward. And I don't think that there's been a decision made on it yet. But New York state courts have encouraged parties as a general matter to pursue discovery remotely where possible. And so I think that's sort of the general understanding right now, but I think it will be seen what happens after COVID is over. But that's the current state of the law here. Just big picture, I think what came through and what David was saying is that the key points are to plan ahead and to be detailed. And so, there's a lot of preparation that goes into taking a deposition, both the substance and the logistics. And I think when we're doing it remotely, that's heightened all the more just because there are so many more steps to consider. So just a couple of quick things. The first one is to know the rules and to know the practice and wherever you are. So for example, in New York, there are particular judges that actually do have proposed stipulations that lay out the protocols that should be used in a remote deposition. Not every single one does, but some do. And they would expect that that exists and that you're, following those guidelines for the most part. I would also look for judges that don't necessarily have their own proposed stipulations to see what kinds of stipulations they've approved in the past. So what they expect, the way they're thinking about things. And then you also have a good basis to start any discussions with your adversary about how you would, set up your remote deposition protocol. As far as documents, I think the system that David proposed is also my favorite system, but I've seen it done a variety of different ways depending on what people's preferences are. So in some cases, people will still mail hard copy documents in advance and have rules for, the date by which you need to have sent them. It has to be by noon the day before the deposition, or if the deposition is on a Monday, it needs to be noon the Friday before. So that's something to keep in mind too. And for electronic documents, there's, using the platform that's provided by the vendor. There's putting them in the chat function, similar to the way you could on Zoom, just putting the PDF in the chat for everyone to see. I've seen people send zip files in advance and then send the password for the zip file right before the deposition starts. So there's lots of different ways to do it. And I've seen protocols that lay out various options with different timing considerations based on what you're doing. So that's something to keep in mind too. As far as the system, I thought the practical tips for how to set up your environment when taking a remote deposition was really helpful. So I thought I would just share mine. I love screens. So I have a dual monitor set up where the witness is on one and I have all of the participants in, smaller tiles on the side. And then I have my outline and the deposition platform that's being used for documents on another screen so I can see that. And then I have an iPad that's set up separately for my real-time feed so that I can read the transcript at the same time and sort of move that around. And then if I'm really being ambitious, I'll have a separate laptop that's just for, doing research, looking up documents, communicating with my team. It looks sort of like a scene out of the Matrix. And I actually love it, and it's super efficient, and I'm struggling to wrap my head around what it will be like in the future when we're back to in-person and I then don't have myself surrounded by screens. As far as practicing the tech, in addition to what David said, I do think it's helpful to practice the tech with someone from the vendor in advance, and they're usually very happy to schedule that. So if you're using a vendor you haven't used before, you can ask them to set up a run through with you. And I would also make that available to anyone else on your case, your adversary, other witnesses, so that they can all practice doing it in advance, and then you're less likely to have technical problems. Another thing to keep in mind is that everyone should have a backup device. So, your witness, the other side, you should ask them to, have something available for their witness, not only having the main device, but if possible, a backup so that if something happens, that's there. As far as preliminary instructions, I think the ones that David provided were great. One thing to keep in mind is I would also talk to, if you're prepping a witness, talk to them about those preliminary instructions too, because I've seen cases where, all the lawyers know that there are preliminary instructions, but the witness has no idea. And, they've gone through what their background is, what their name is, their education, what they did to prepare. And then suddenly they're being asked about where their phone is. And they get flustered because they don't know what to do. Or like if someone else is in the room, they're like, I don't know, my wife is home, and they get nervous about that. So I would also make sure you talk to the witnesses so that they're aware of it too. One related point is breaks. I think we all focus a lot on the technology we use during the deposition itself, but then also need to think about what do we do on a break? How are we going to either talk to our teammates, talk to the witness if you're defending? And so there's a few different options for that. There's breakout rooms, either self-guided if you have that capacity, or done by the vendor. I personally don't use the breakout rooms because they scare me and I'm never sure if they're going to work properly. And I, often work with clients who aren't necessarily going to be able to navigate the breakout room and successfully come back to the deposition room. But that is one possibility if you have a tech savvy group. But I'll often just find an office down the hallway where, I'll agree to go on every break and, call using a different phone. So that's something to think about too, is how you're going to communicate during break times to make sure that, you're not inadvertently somehow divulging attorney-client privileged information, in the deposition itself while it's being video recorded. And then the last point is, 2 points. One is we have an ethical duty as lawyers to be competent. And I think technological competence has always been a piece of that, but something that we don't necessarily think about. And so I view this as one, probably a year ago, that would not have been the expectation. But I think now that we're all using Zoom, we're using these platforms, being able to navigate how to pull up an exhibit, how to scroll to the right place, how to mute yourself and come back off mute. Those are all things that are sort of an expected part of practice now. And then the last thing is on the energy point, which I thought was a good one, is treat the virtual deposition the same way you would an in-person deposition. So I drink the same amount of coffee. I have the same Red Bull next to my desk. I banter with my witness the same way I would as if I were in person, make jokes, talk about the weather, whatever it is that can make it feel real, like you're actually trying to build a relationship. That's how I try to think about it. If I were meeting someone for the first time in person, making a friend, going on a date, whatever it is. If I'm trying to build a connection, I approach it that same way so that the screen is not what's preventing someone from being forthcoming and having a rapport.
Well, Mark, thank you so much for your insights tonight. And I think we can all benefit from that. I know for myself, I've always thought about the cost of it too. I know, like David had said, sometimes flying in for a deposition and burning through 2 days and staying in a hotel and having to justify that expense to your client, this kind of gets rid of that issue. I know that Gabriel and Daniel are going to talk about preparedness in the tech age, including the ethics of it. So I'm looking forward to their comments about depositions. Josh, did you have anything to add that you'd like to add about depositions?
Yes, thank you, Hillary. I think there's 2 points that Mari and David were talking about that I would just add my 2 cents on. First, like Mari was saying, New York isn't quite as controlled in our rules for remote practice as California might be. And so it leaves a lot to the lawyers and courtesy between the lawyers about what to share for exhibits or not in advance. And I'll tell you my own philosophy in cases like that. In many cases, it won't be any secret among the lawyers what exhibits are going to be used. A simple motor vehicle accident, for example, everybody knows that you'll use the accident report, you'll probably use the vehicle photos. You're not giving much away by exchanging that in advance, you're just streamlining the deposition. But I think an element of any deposition in regular non-remote times is the element of surprise with a witness. And in a case with a lot of documents or where it's not totally clear where you're going, the element of surprise might be the difference between getting good testimony from a witness and bad testimony, because they can prepare around it. So I'd say in cases with a lot of documents, you might want to hold some documents back rather than roadmap exactly where you're going and what you're doing with it. And then put them on the screen for the first time and let the witness not know what's coming. Again, try to keep them off balance where you can. And I'd also say, just as far as the question of whether to put documents on the screen yourself or whether to use a vendor, personally, I found that it's most effective where possible to do it yourself rather than through a vendor. It gives you more control over zooming into certain areas. It gives you more control over the timing of the deposition. And it also avoids an instance where you're relying on Monitor to be really quick with the exhibits and they're not as quick as you need them to be. So to me, I think the more control you can keep for yourself rather than sacrificing it to the remote environment, the better. But Mari and David were very thorough and I agree with everything that I said.
Thank you. I saw a question in the chat. Do you want us to address those as we go?
You're welcome to. I did see that one if you'd like to address it, Mari.
The quick answer is for whether I run my 2 monitors from a single laptop and what kind of splitter adapter I use. It was incredibly complex. I talked to Best Buy about 6 different times and bought probably 10 different types on Amazon. So it takes a lot of work. It's worth it in the end, but I won't bore you with all the details. But the bottom line is it takes a lot of research. So you'll have to spend a little time up front doing it.
Like any good investment of time. And Dan, I know that you've attended depositions too, and you had some insights here that you were going to share.
Yeah, thanks, Hillary. I want to just sort of piggyback on what my colleague David, Lynn, Manuel, Lefkowitz said about being in the room where it happens. I've had depositions where party witnesses were not giving their deposition, will have their cameras off. And in that situation, you don't know if it's the person who's there, who else is in the room with him or her, who are he or she talking to. Maybe it's not a big deal, but in situations where there's confidential testimony that's being discussed, you're under an obligation to make sure that you know who's in the room. And it's really important to make sure all the witnesses have their cameras on, so you know who's talking, who's present. In a conference room, it's pretty easy, but in these Zoom depositions, there's some pitfalls you have to be really careful of.
And clearly we know the next subject, which Dan and Gabriel will be speaking to. But before we get to that, Gabriel, did you have some insights that you would like to share?
No, I think everyone's covered it really well. I guess one thing, so just as sort of a confession, I'm more of a white collar criminal lawyer, and I'll be sort of talking about the stuff that I know. But one of the things, at least on the criminal side, working with prosecutors, I think one of the advantages of all of this remote practice has been that it has caused us to have a lot more dialogue than maybe we would in advance of a normal interview or deposition, and has created space for sort of negotiation, but actually just sort of a recognition that this is a difficult area. And I think that kind of dialogue has been really a positive result of all of this. And so I just wonder, especially for the civil litigators, how has, with plaintiffs' lawyers or defense lawyers, like how has your communication with the lawyers been impacted by the need to kind of coordinate this stuff?
It's a good question. Mari, what's been your experiences here?
I feel like I definitely talk to my opposing counsel much more these days than I used to. You end up talking much more about the details, working through the logistics of things in a way that's just in more detail than you typically would have. But I actually think it's been helpful on the whole to keep that line of communication open. And it makes dealing with the substantive issues sometimes easier too, since you are in more frequent communication.
And Josh?
Yeah, I totally agree with that. And I think, one thing that we've all learned from doing virtual litigation is that cooperation is necessary to keep things moving in a way that you might have been able to work around before. So it that much more encourages collegiality, it encourages people to collaborate, and it encourages people just to cooperate to keep a case moving, because if you don't, it's going to grind to a halt, which is in nobody's interests.
Or it gets before the judge and then you hear about it there. David.
Yeah, and then the judge won't be happy either, which is a loss to everybody.
David, what are your thoughts?
Well, I'm really happy that people are talking more to opposing counsel. I don't think that that was. I think that's an excellent side effect. I'm not sure that that's happening as much, at least in the situations that I've been in because we can just simply send out notices, and perhaps where you need to work through a stipulation, then you'll have more of an opportunity to do that. As far as speaking during the deposition, I find that there's no issue at all, that communication is free and easy, and perhaps better because it's sort of a shared change and transformation that we're all going through, and that itself is kind of a bonding issue. And I just think that there's not enough communication among counsel, and there should be more. And I'm happy to hear that that's happening around with the lawyers that are participating.
Yeah, I think we can all agree communication's improved in most instances. And I know that this probably will segue into the next part of our presentation, which is use of technology and preparedness, including the ethical aspects of it, which we all have to be aware of. And Dan, I'd like to hear your thoughts on the deposition, if you have any points to cover there. And then we're going to talk about California's ethical duties. And then Gabriel will be talking about New York's ethical duties, as well as some other preparedness tips. And I think that we can all agree that we all have to be aware of ethics, and the more we know about it, the better off we all are. So, Dan?
Thanks, Hillary. I'm honored to be here and speaking with everyone. I'm David's much younger California colleague. My office is in Beverly Hills, just about 5 miles east of Dave. I'm going to be talking about a California lawyer's ethical duties when working remotely. The short answer is they're the same, but there are some pitfalls you have to be careful of when working remotely. I think some of these sort of dovetail or overlap with what Mari and Dave were saying about depositions, but it's important to accentuate some of those. So the California Rules of Professional Conduct, Rule 1.6, the duty of confidentiality, says that a lawyer shall not reveal information protected from disclosure by Business and Professions Code Section 6068, subdivision E1, unless the client gives informed consent or the disclosure is permitted by paragraph B of this rule. Now, every lawyer knows this, but working remotely, what are some areas that might impact this rule that you would not necessarily think of? So, and you can move to the slide 3. Tips for lawyers. When working from a home office, make sure you're not sharing a computer with family that allows anyone to access files on your computer. So you are reviewing your documents for your deposition the next day. You've got some confidential files on your computer. Your daughter's coming up to do her homework, and she's looking at the Mattel's trade secrets document that you're going to be using in your deposition tomorrow. Well, that's a bad idea. So make sure that your office, your computer that you're working at home is password protected or a separate place. When you are having video conferences with clients, consider having passwords to access those so people can't randomly eavesdrop on your conversations with your clients. You're under an obligation to maintain the confidentiality and keep those zones of privacy for when you're talking with your clients. And along those same lines, establish areas of privacy where you can have conversations with your clients that are privileged, and remind your clients of the same. So working from home, I'm in my back office, very common. I'm on the phone with my client, and I'm on the phone, I'm doing this to my daughter who's coming in trying to talk with me. And it's innocent, but if you're having a conversation with your client and someone else is in there, that particular part of the conversation is not privileged anymore. So you just have to be careful and remind your clients of the same. So the next slide is just some practical advice for your clients. Remind them to follow strict procedures to maintain the confidentiality. For virtual mediations, hearings, and depositions, as all lawyers know, clients must be reminded and reminded and reminded. Mute your microphones when engaging in your private conversations with your lawyers. Very important. You're in a break for a deposition, you're on the phone, you're on mute, your client's not, and everyone can hear what he or she is saying to you. Establish areas of privacy where you can have conversations with your client, your lawyer, with you that are privileged. So not having your kids around, or your spouses, or your colleagues. I mean, when your client is talking to you from the Starbucks down the street and you can hear them ordering while they're talking to you. I mean, stuff like that makes me insane, because now you're just broadcasting to the world not only what your coffee order is, but what your attorney's advice is. So remind them to, even though they're not in your office or they're not somewhere private, you have to be maintaining those areas of privacy to maintain the confidentiality of those conversations. And we have an obligation to make sure that we harp on that with our clients. The next rule that Mari spoke about specifically is the duty of competency. New York certainly has a corollary, but in California, it's a Rules of Professional Conduct 1.1. A lawyer shall not intentionally, recklessly, with gross negligence, or repeatedly fail to perform legal services with competence. So make sure that you know and you're familiar and competent with the technology that you're using for a deposition. And effective March 22nd, 2021, California amended this rule to incorporate a version of Comment 8 to ABA Model Rule 1.1, which is commonly referred to as a lawyer's duty of technological competence. The duties set forth in this rule include the duty to keep abreast of the changes in the law and its practice, including the benefits and risks associated with relevant technology. Now, what kind of risk are we talking about here? This is something that I'm sure everyone has seen. And if we go to the next slide and help me out here.
Mr. Ponton, I believe you have a filter turned on in the video settings. You might want to take
we're
a
trying
look.
to, can you hear me, Judge?
I can hear you. I think it's a filter.
It is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I can see that. I think if you click the up arrow next to this.
So thanks, guys. As you can see, you don't want to be the lawyer who has to explain to your client that a video of you in court went viral because you had a cat filter on your screen. It seems obvious, but I spoke with a LA Superior Court judge last week, and I asked him, I was like, I'm sure you've seen that video. I would imagine nothing like that's happened to you. And he said, well, you'd be surprised. I've had multiple attorneys show up and with wardrobe malfunctions. Now, just please, if you get anything out of this CLE event today, you can go home and tell your spouse that I learned that I have to wear pants when I'm on Zoom. I'm happy if that's where you get your credit from, take it. But the duty of competence also implicates personal matters that could affect an attorney's ability to practice, such as school closures, childcare issues, health, or finances. Just we have to make sure that no matter what's going on, that we're still representing our clients competently. And anything that can impact that negatively needs to be dealt with. If you need to bring in counsel to assist or seek continuances, so you can represent your clients to the best of your ability, regardless of what's going on with your personal life. And then the last thing that I think is something that's really important to a lot of people who during COVID maybe have moved to remote offices. Maybe they have a house out of state and they're up in the mountains practicing, and realize that, you know, I can actually do a lot of my work without being at my office. Well, you have to be cognizant of the rules that prohibit the unauthorized practice of law or multi-jurisdictional practice of law. And in California, that's Rule of Professional Conduct 5.5, which says a lawyer admitted to practice law in California shall not practice law in a jurisdiction where to do so would be in violation of regulations of the profession in that jurisdiction. A lawyer who is not admitted to practice law in California shall not establish or maintain a resident office or other systematic or continuous presence in California for the practice of law. So this is two things. It's either you're a lawyer in California and you're practicing elsewhere, or you're a lawyer licensed somewhere else and you're living in California. Now, for California lawyers who have temporarily or permanently relocated out of state because they believe they can maintain a virtual practice, what does this mean? Well, Rule 5.5A1 says that California licensed attorneys practicing California law remotely in another state where they are not licensed should consult the multi-jurisdictional practice and unauthorized practice of law rules and authorities of the state where they are physically present. So we have some examples of some other states' laws and rules to give you some practical advice. If you're living in Washington, D.C. as a California lawyer, in DC, the incidental and temporary practice exception under their Rule 49C13 permits an attorney who is not licensed in the district to practice law from their district residence, as long as the attorney is, 1, practicing from home due to the COVID-19 pandemic, 2, maintains a law office in a jurisdiction where the attorney is admitted to practice, 3, avoids a DC address in any business document or otherwise holding out as authorized to practice law in DC, and 4, does not regularly conduct in-person meetings with clients or third parties in DC. And this was a DC Court of Appeals opinion number 24-20. So what does this mean? Well, if you are a California lawyer practicing in California but living in DC, you cannot do so unless you're practicing from home in DC due to the pandemic. That's a specific requirement. You also can't meet with clients at an office in DC because that could be holding yourself out as a lawyer practicing and licensed in the district. So the DC rules are pretty strict. If you move on to another state, Florida, an out-of-state attorney physically working from her home in Florida for a matter for her New Jersey law firm is not committing the unauthorized practice of law in Florida as long as she does not hold herself or her firm out to the public as having a Florida presence, does not give advice about Florida law, and provides no legal services to Florida residents. Now, that last one I think is interesting. Even if you are representing a Florida resident in a matter in New Jersey where you are authorized to practice law, under this rule, you would be violating the multi-jurisdictional rules of Florida. Again, very, very strict requirement that we have to be cognizant of if we're working out of state. Another state, Utah, where I actually have a California lawyer friend who's moved, hopefully temporarily, but she's there for at least a year. An out-of-state attorney is not prohibited from representing clients in the state where he is licensed, even if the out-of-state attorney does so from his private residence in Utah, again, provided he does not establish a public office in Utah and does not solicit Utah business. So You can practice in Utah as a California lawyer, but you cannot have an office there, and you cannot solicit Utah clients. So even if you're representing a Utah business in a matter in California, you cannot solicit other Utah business for matters in California. So we need to be careful that we're following our ethical rules, as always, and that we're keeping up to speed on new considerations that may arise when working remotely.
Thank you, Dan. For I think that we can all agree that the insights were great there, and I know that of particular interest to a lot of people are the multi-jurisdictional practices when you're working in other areas. Or I know that I've had it come up, and a lot of attorneys have it up. What are the rules and obligations if you're doing a remote deposition and the other person lives in another state? Do you have any comment about that question? And Gabriel, I was going to ask you the same question too.
I don't have any specific comments on that, Hillary, other than, make sure that you're complying with the rules as far as admonitions to a witness in the other state, and perhaps stipulations for the maintenance and record keeping of the deposition transcript. Maybe Gabriel has some additional insights on that subject.
Gabriel, and yes, is Gabriel who's going to also talk on the same subject matter. So Gabriel, what are your thoughts here?
Yeah, so I mean, maybe I'll pick up from where Dan left off, and I'll start again with my confession from a few minutes ago that I'm not a trial lawyer. I'm a white collar criminal civil investigations lawyer, which as a rule means I'm trying to keep my clients out of courtrooms and out of depositions if at all possible. But I do think obviously the rules that Dan was walking through around remote practice or just ethical practice of the law applies generally, including to people in my practice and regardless of the practice area you're in. And so I'm planning to sort of take things back a level of generality and talk a little bit about the competency and a couple other topics as well. But in terms of the New York versus California, obviously very similar principles apply. And in your material, shout out to the material I think that was linked at the beginning of the presentation. We included an NYCLA ethical opinion from last year, as well as an ABA opinion from this year that kind of walks through these different topics that Dan and I are touching on. And I really encourage you to read through those, and they provide some really helpful tips in addition to the ones we're providing. But the one I wanted to focus on is in paragraph 7 of the NYCLA opinion, and it kind of talks through the implications of remote communications. And so obviously we're doing Zoom, but your other options might be to meet in person or by telephone. And every time you're choosing to engage in a discussion with a client or with a counterparty, with a regulator, you have to be making that choice consciously, ethically, and competently. And it's really easy in our practice to sort of default to what's on the table. If someone calls you on the phone, someone proposes a phone call versus a video conference. But it's our obligations as attorneys to think through the implications and think through whether the way we're communicating is done, consciously and thinking about the downside risks. And we've all been living through the downside risks of remote practice, including a difficulty in establishing rapport, difficulties with the media. We saw the I'm a cat video, miscommunications, talking over one another, distractions. And so, all this is sort of just a bit of a red flash. Everyone just needs to pay attention to what they're doing and be very conscious in their choices. And maybe in some sense, we haven't had a lot of control over the way we communicate during the pandemic. But especially as we move forward, we're going to have more and more decision-making around whether this particular encounter, this deposition, this court appearance, whether it should or shouldn't be in person, whether it should or shouldn't be remote. And we're going to be needing to make those decisions with our clients' best interests in mind. And I just have a couple of anecdotes from my own practice, again, on the regulatory side. The first is that until 2020, I don't think I could count on one hand the number of times I had a video conference meeting with a regulator. I would say it was just very rare. We would usually either speak on the phone for a periodic check-in, or we would meet in person for a more serious discussion. But since the pandemic, while our more serious discussions have happened almost entirely remotely and by video conference, our more periodic check-ins have also happened by video conference, which has been a huge change in the way we practice law. And it sounds like a small thing, but when you're interacting with a regulator who's going to be making major decisions about your client, and you interact with them face to face, whereas before maybe you were meeting them once a quarter, now it's once every other week, once a month, that can really have a major impact on the dynamic and the relationship you have with that regulator. And then the other anecdote is that last week, I had my first ever, since the pandemic, in-person meeting with the regulators. And we sat in a room together, everyone was masked, we were all socially distanced. And I was very skeptical that it was going to be a very awkward experience. And I'm pleased to report it was really great. Maybe we were all just desperate to get in a room with each other, and we were at this point used to sort of speaking with masks on. But I think it sort of drove home the point that we've all been feeling, which is that there's really no substitute for in-person communication. And they're really, when we get that opportunity again, we're going to want to dive in and really start to have in-person communications and meetings. And so all of this, this is all building up to, paragraph 7, thoughtful, competent, effective decision-making by lawyers, and then the sort of pros and cons of different media, including in person. I think post-pandemic, pre-mid, whatever we're in, we're going to be making decisions about how to communicate. And I think, and in particular, that maybe there's no substitute for in-person, but there might be a substitute for telephone calls. And I think one of the things that we should be thinking about as lawyers going forward, and one thing I've been thinking about a lot, is how much of what we might have picked up the phone for before the pandemic, we could now do by video and would actually have a bigger impact. And we maybe going forward, it's become an option and available tool within our toolkit as lawyers, and being competent lawyers and being the best representatives for our clients. I just want to throw that out there. That's a theme I think that's come up a bunch about how things have changed, potentially for the better. And as lawyers now, we're sort of moving into a new area of the law, if you will, through technology. And I'll probably come back to the end of the presentation if there's time. But the other thing I want to talk about very briefly, we didn't touch on, is supervision. This is covered in both of those opinions that are included in your material. If you're working in an environment where you're supervising a lawyer or you're supervising a non-lawyer, you have the obligation to make sure that they're satisfying or meeting all the ethical obligations that Dan was describing earlier. Are they using encrypted devices? Are they protecting your client's privileges? Are they competent with technology, or are you making sure they're well trained? Are they communicating effectively with the client despite the sort of reduced interaction or different kind of interaction? And then also, how are you engaging with them? Are you meeting with them using video, or are you defaulting to the telephone again? Or are you considering, the frequency with which you're communicating with them? Has it changed since the pandemic? And are you exploring potentially in-person meetings with them, obviously in a safe way? I think the other thing, again, I'll preview some of what I'd like to talk about at the end, but I think this whole pandemic has put a lot of pressure on this apprenticeship model of practicing law, where partners and associates are supposed to meet together in the office and get sort of one-on-one supervision. But in reality, there was a lot of other pressures on that practice of law, right? I work in a practice that can sort of have people flung across the country, across the world at the same time. And there's a lot of the new tools that we have, again, as lawyers, are now making it possible for sort of video conferencing to be the glue that maybe keeps teams together. Also, as we explore a more sort of hybrid or pseudo remote environment, some people are going to be home, some people are going to be in the office. Are there ways in which video conferencing can really prevent what's called distance bias, basically keeping the people who are outside of the room from feeling like they're missing something and not integrating into the team? So that's my 2 cents on competency and supervision. Hope it's helpful.
Super helpful. And Gabriel, thank you for all of your insights and your contributions. I know a big part of this presentation is not only some of the guidelines, because when you look at a rule of professional conduct, okay, what does this mean for me? But I think it's really helpful for everyone. I know myself included. I think I have not asked everybody here, but I'm sure at one time or another during the pandemic, you've called a colleague, say, hey, how are you handling this? So there's a lot of that, I think, here too. And for myself personally, I know I was thinking about this about technology. I didn't know what Zoom was really when the pandemic started, and I certainly didn't know how to use it. So I was thinking about listening to Mari and Dan and everybody talk about being competent, and now I can do my own screensavers. I can do all this. I think it's really essential. I know that Josh and I are going to segue into the next part of the presentation, but David, what are your thoughts here?
The only thing that I would add to the excellent thoughts of my predecessors is the element of delay. The problem that I have encountered with delay, people taking advantage of the congested courts, and also the constant rolling need to put things off, to the point where I think it's become abusive. And when a court, for instance, one court I'm in, if I wanted to reserve a motion date, the next available motion date is sometime in 2023. And so, that's for real. And when that occurs, it gives a great opportunity to in my view, unethical attorney to just take positions which force me to make motions that shouldn't have to be made. I don't have that in all of the courts before all of the judges, but it's something that has really rankled me, and I don't know whether the state bar is thinking about doing anything about that, but I think it's an ethical issue, and I think it's got to be dealt with.
I agree. I think there are always people who will take advantage. Mari, what are your thoughts here?
I agree with that. I think that we have to hit a point, at least in New York, and I love Josh's thoughts too, but I think those of us here feel like things actually have started to go back to, or at least move in the direction of going back to working on the same schedule as they used to. Hearings are being scheduled more quickly, oral arguments, motions are being decided more quickly. So the same delays that we were seeing at the beginning of the pandemic aren't really there anymore. So at least here, and I practice in Delaware Chancery Court a fair bit, and it's the same thing there. Things are moving along quickly and efficiently as well. So this is not as much of an issue here.
And I know for our next subject, we are going to talk about one of the reasons we're here is remote hearings and trials, which Josh and I are going to talk about. Josh, could you give us your thoughts about the comments we just had this section? Then I think it might go in nicely to the next subject.
Yeah, sure. Let me just touch on what Mari said, which I almost entirely agree with, and then I think we can move to the next one. Mari is absolutely right. I think that a lot of what we're seeing in just the general rhythm of litigation is it going back to the schedule that we were on before. The one area where it can be different is in some counties of New York City for state court. It's harder to get a compliance conference or to just deal with a mundane discovery issue by having the court bring you in to deal with it. So it relies a little more on the litigants to provide their own forward momentum for the litigation. And you have to work just like very slightly harder to supply it yourself if you're not being called into court every month or two to report on status. But I think Mari is right that people have found ways to work within that framework and keep the litigation moving. It just takes a little more conscious effort.
Thank you.
Okay.
Yeah, I was going to say, why don't we, the next subject here that we're going to talk about, and again, something near and dear to all of our hearts, it really is, that's why we're here, is remote hearings and trials and some of our experiences, guidelines, and what we can reasonably expect. And I know a big question in everyone's mind, are we ever going to have in-person jury trials again and trials? Or are we just going to look at each other on the screen and do it this way for the rest of our foreseeable future? So Josh is my very able colleague on the East Coast, is going to start us off.
Thank you, Hillary. So just from my own experience during the pandemic, I've had two really major remote hearings and trials and then some more minor things. The biggest one was a 3-week-long remote trial in New York's Court of Claims. In New York, if you sue the state of New York, you don't get a jury trial. You go into something called the Court of Claims, which only hears cases against the state and where you get a bench trial. And so in this case, even though we had 10,000 pages of documents and numerous expert witnesses, the judge felt that it could be tried remotely, and she turned out to be right, and it actually went a lot smoother than any of us would have expected. And then the second was a framed issue hearing in Bronx Supreme Court, which involved expert testimony, lay witness testimony, and legal argument. And based on that, and from talking to colleagues about what their own experiences have been, here's what I would say. The first is I think you need to prepare a little bit differently for a remote trial. First, I think with your documents and exhibits in particular, you want to prepare farther in advance. Because in a typical jury trial, if you're physically in the courthouse, you subpoena your records to the court. Sometimes you find out right before you're going to start that you're missing a certification. You can serve a subpoena on the doctor's office at the last minute, and maybe the office manager comes down and certifies them. That's not going to happen in a remote trial. So the first thing that I would say that everybody should do very far in advance, like farther than you really think you need to, is confer with your adversary and stipulate in as much as humanly possible, even if you have to give a little bit to get a little bit. Because the challenges of authenticating evidence can be very difficult, especially as it relates to certifications, if it's not all put to bed in advance, or if you're not very confident in advance that everything you need is in the right place. So that's the first thing that I would say. Second is when you're preparing your own witnesses, you need to do a couple of things that I would say would be additional or different. First, don't leave anything to chance with your own client. Make sure, number one, that they are prepared for how to testify in a virtual environment. So much of putting on a trial and putting your own client on is having them able to connect to the trier of fact. There needs to be not just words ejected into a Zoom chat, but a connection with the finder of fact. And so what that means is teaching them, just as they would make eye contact with a jury while they were testifying, to try to make eye contact with the camera where they'll be looking into the eyes of the trier of fact, or at least have the person evaluating their testimony feeling that they're doing so you don't lose that connection. Second, don't leave anything to chance with your client testifying. If you think that your client is flaky or not able to be where they're supposed to be or doesn't really know what they're supposed to wear, make sure that you deal with all of that in advance. And that's not a unique challenge to the virtual environment. I had a case a couple of years ago where I told my client for his deposition, he said, "What do I need to wear, Josh?" And I said, "Just make sure you wear a collared shirt." So he comes to my office, he's wearing a collared shirt, but it's short sleeved, and he has a gigantic sexually graphic tattoo on his bicep. So I said to him, maybe you should have worn sleeves. And so I had to send him out to Century 21 with $10 to buy something else. In the virtual environment, people will sometimes be testifying from their living room, and there is that much higher a possibility that there is something there that you don't want the judge to see. So don't leave anything to chance. When you prepare experts, I would say something that you can lose when you're putting on a presentation virtually is you can lose some of your rhythm when you change documents or put up a new one or show something to the expert. So what you want to try to do is make up for that on the back end by being really careful when you prepare an expert to tell them what document you're going to be showing them, exactly what you're looking for in the document and where you want them to be, and then what you're going to segue into next. So the expert can be smooth in the presentation and you don't lose your rhythm by switching between the documents. And you may even consider whether you want to drop the exhibit altogether if it's of only a marginal benefit. In one of the things that I did, I was putting on an expert psychiatrist. And maybe in a regular environment, I would have shown him a prior doctor's notes or even done a blow up with it to show that his opinion and the prior doctors were consistent. And in my trial, I chose to drop it because I felt like the additional barrier of switching between the exhibits and directing him to something and telling the court monitor where to scroll, it just wasn't worth the loss of flow and rapport that I had with the expert in the testimony. So that's what I would say about prep. But basically think about whatever challenges you would have virtually and try to address them in advance and know how you're going to deal with them in advance. Then the trial itself. One actual challenge that we have in New York that you wouldn't have regularly is technically, unless you work out a stipulation, a notary in New York or a court officer in New York may not be able to swear in a witness who is in another state without stipulation. So make sure you deal with it in the trial judge in advance if you're putting on somebody from out of state, or else you can run into a really catastrophic issue at exactly the wrong time where you can't get your witness testimony in. Now, when you're questioning a witness, and remember, trial is theater, what you need to try to be able to do is make up for some of the loss of intimacy that you would have with a witness if you were in person. Because when your client is in person in a courthouse, they're right there with the jury. The jury sees them walk in every day. They're in the front row. When they get up there, they're able to turn to the jury and make eye contact and use hand gestures. And you will lose some of that by not having your client physically present in front of the judge. For me, the way that I've tried to deal with that is to treat an examination of my own client a little bit differently and try to make it less formal when I'm doing the questioning, to almost make it feel like a conversation between me and the witness. And you can't really do that in court. Like, there's a formality to it from you being at a podium and the witness being somewhere else. But we're all now accustomed to having these very informal conversations over Zoom. And you can be a little bit more reactive with your client. If they're saying something emotional, you can show your own emotional reaction to it, and it'll be something that might be seen by the judge. Or if they say something, you can even play off of it and say, that must have been very hard for you to deal with. You know, how did you deal with that next? Or what did you do with it? And you don't want to abuse it because at some point it becomes contrived and annoying and gets in the way. But it's okay to have some intimacy to the conversation over Zoom with your own client, even if you wouldn't have it otherwise. The other thing I talk about is cross-examination. In a courtroom, you can control a witness in a variety of ways to keep them on track. And some of that is, for example, diverting their eye contact away from the jury. You'll walk across the room so they're looking at you, not the jury. Or you can use your physical presence to control them, to cut them off, to stop them from running roughshod over your question. You have to work a little bit harder over Zoom, I think, to control a witness on cross. For me, I think the one thing that you still have that they can't do a lot about is you can still try and control the speed of the cross. And to me, what that means is you want to try extra hard to, as soon as they finish their answer, don't let them catch their balance and get your next question out as soon as you possibly can. Even if it means erring slightly on the side of getting your question out if you're not totally sure that they're done. Get your next question in and let them know that you're controlling the tempo and try to keep them back on their heels and not too comfortable. But you do need to work a little bit harder and a little more consciously to do it. One of the things that I would also talk about is non-virtual trials. Hillary asked at the beginning, will we ever go back to regular trials? And in New York, in some counties at least, they've started to do some in-person trials. But those come with challenges too, because the judges will sit behind plexiglass. They'll use bigger courtrooms that weren't always intended for jury trials. So the jurors will be all the way in the back. The witness will be all the way at the front. The jurors will have masks on. Sometimes the witnesses may even have transparent masks on. And so for us as a law firm, that poses challenges to whether you want to do it to begin with. And the philosophy that we have had is, on a really serious case, if you can avoid it and the client can afford to wait, you don't want to try it under the current circumstances where the COVID precautions will be a distraction. A simpler case, maybe one with very slightly less severe injuries, you want to think about it. But a real catastrophe case, at least as of now, we feel that those should, at least when possible, wait until we can try them in a more regular way. And I saw that one of the questions in the chat was, what is our sense about whether remote trials will remain common after the pandemic ends? And I'll say, for me, I didn't feel like we lost a lot in our bench trial. I think that the judge adapted very well to it. I think the litigants worked well together. And so I think in places where you have a finder of fact that is comfortable doing it remotely, first, they will be more common. And second, the finders of fact will have ideas of their own. So if a judge liked doing bench trials and liked not commuting to the courthouse, or liked the fact that the trial moved more quickly from witness to witness, we're going to have them whether we like it or not. And I think we'll see some of it. But as far as remote trials where there's a jury, I would never want to do that. And I don't think that that's something that we are likely to see in the future. So those are my thoughts. And Hillary, I'm interested to hear yours.
Thank you, Josh. And I've had 2 trials during the pandemic, and I'm actually in the midst of an in-person one right now that we got a week off, and we go back next Tuesday. The one trial I had was remotely resulted in a directed verdict on a technicality really fast, which I think highlights what I know a lot of people have talked to. I know in preparation for this presentation and others I've made, I talked to a retired friend of mine who's actually retired New York judge, and some of the things that I'm hearing from judges, and I'm sure a lot of people are, yeah, everybody's different, but I'm putting my life at risk to come to work, whether you guys show up here or not. And the pleadings become much more important. You have to write tighter. You have to do these things. I mean, we've all seen sloppy work. I won't say, embarrassed to say that I have been guilty of that. And I'm sure there are times I had, oh my God, I can't believe I put that in. It was late and I felt good about going to bed and I didn't give it that extra time I need to do. And again, pleadings are going to be real important. You have to be organized. You've got to do this. Another trial we had, and before the pandemic hit, we were doing sort of these quasi trials where everybody didn't have to show up. There were witnesses from another state. I know I tried one a couple of years ago where my client, who was essentially the plaintiff, had a surgery and she was well enough to testify, but traveling was out of the question. And we made arrangements for her to appear remotely and the court accepted that. Her daughter was with her. I think we're seeing a lot of that, and I think we're seeing quasi-blended type trials. The issue I ran into, for example, last spring, as we were set up to appear remotely, the judge was fine. Technology, again, you need to know how to do this, and you need to be comfortable with technology. You need to know how much it's going to cost and what you're going to be able to provide. The courts aren't set up for that. I mean, we had Enmo or something for it looked like a screen. I'm in my 50s. This looked like a screen projector that I remember from junior high or high school, where you put a slide on and your teacher's writing on a math problem or something. That's about what they had there in the courtroom. And again, I'm not in any way knocking the court system, but at least in California, there's just not the funding for it. And they don't have the technology for that. The lawyers are expected to do that. And a lot of what we as lawyers need to think about is what can we as lawyers do to make sure that these things go smoothly and that we have the technology there. I know, for example, some of our written materials, and I know it's in a lot of local rules or just people are asking about this, lawyers are expected. And again, I think part of our attachment is the Florida best practices. You look to a lot of other states about what they're doing recommended. If you look in those, and I'm sure it's a lot of judges feel this way, is that keep the technological problems to a minimum. You're expected to cooperate. You're expected to know this. Attorneys, when you show up, you're supposed to be doing that. I don't think any judge wants to sit there for 45 minutes while someone's fumbling with an exhibit. Your Honor, I'm sorry. I'm not a cat is really funny, but we've seen other ones. And again, this is work. The judges are putting themselves at risk even going in. What I have seen is a trend of judges, and some have been very nice. Again, even before anyone got vaccinated, we were eligible. We went and had a 6-day bench trial. The judge was very nice. Some people were going to appear by phone and some people weren't. We were going to appear remotely, but once we found out everybody else was appearing in person, we didn't want to lose that aspect of presence. So we made the decision to go in, which wound up being a good decision in this. But I will tell you, everybody was very uncomfortable. And the court reporter was jumpy, don't come too near me with witnesses. After everyone would go up to the podium, they were going and cleaning it. They were very diligent about it. But I've seen other courtrooms where I was really, I didn't even see any sanitizer. I saw the judge was behind the screen and behind several panels. But what I am seeing in trials is judges are either being very candid. A lot of them do not have a lot of patience right now for gameplay. And not to in any way suggest, I know that no one on this panel would do that. And I know I'm not suggesting anyone who's attending who will review this would do that, but we have to face reality. We see people play games, exploit the process, and, will use something to their advantage. And, a lot of that judges are not putting up with it. I was in court a couple of weeks ago and, the judges said, no, she's like, no, here's what you're doing. And they're very much like this. So again, I see judges really taking control of their courtroom. Judges, as you know, have different philosophies as to how they're going to run their courtroom, which is totally fine. But I am seeing, as a whole, judges are not, some of the things that the judge are like, oh God, you're going to do this today. It's not going to happen. Use of exhibits. it just seems to be a continuing problem with some attorneys not to think about authentication before they go to trial. And they're like, well, I have all these documents, and they have like, some that have been texts, emails, you're going to authenticate those, but those aren't too hard to do. But then they have people showing up. They're like, oh, well, I have, I have a legal doc, I have a bank statement, things like that. They haven't, I have, the case we tried last spring it had to do with a real estate matter. No one had thought to authenticate these documents. Some had been signed, some hadn't. No, no one even discussed it. And we kept sending emails like, hey, do you guys want to meet and confer? And so, of course, when we got there, it was, I thought about it for a second. She said, what do you want to do with the exhibits? And we spent 2 hours going through them. And I thought, I could just object right now and knock his case out. And I'm like thinking about what the judge would do to me if I did do that. And, those are decisions which I think before the pandemic were easier to make. Now they're a little more difficult. And I don't see a lot of judges being real receptive to that. At least that's been my feeling. And that's going to sort of segue into my next point here. Civility is a lot more important now than it ever was. People have, there's going to be sleazeball attorneys. There's always going to be those. There's going to be people who are unprepared. And whether that's they're being just unprofessional or sloppy, or they're just like that. Being civil to attorneys, which I know I've sort of seen a trend with more communication. I don't mean it means they're friendlier, but I think that's been happening because they have to. But you're seeing a lot more cooperation with things, handing things to them, which I would never have done before the pandemic. And I think it's sort of necessary now to do that. And I think it's part of our responsibility as attorneys. I'm not saying to give them anything or to give them any part of your case, but I am seeing a lot more of that. Like Josh said, they're going to court planning well ahead of those. I mean, David's right too. It is kind of nice, when you go in and you're like, hey, I don't have to make, I'm not going to have, 2 huge briefcases full that I'm toting with me, lugging along through up the stairs to get up to, to bring into the courtroom. And I'm not going to even use those today. Okay, what am I going to do with all this paper? That's nice to have that. But attorneys getting along and stipulating the things, always confirm it in writing. There's still that one thing, I'm sure everybody knows this, not to treat anyone like they're stupid. But sometimes I still see people going, oh, well, we talked about that. I'm like, yeah, where is it? Is it in writing? So I'm sure my staff can tell you, because I am always on them about that. I think that one thing I did notice is use of remote witnesses. There's still this sort of, even if you're in person, not just the remote, like, for example, I'm seeing a lot of sort of quasi, blended, we'll call blended or trials where some people are showing up and some aren't. You've got to make sure that you know how to get that person into the courtroom. If you show up and go and they're calling in, no one is going to be happy with a court call or giving them the phone number for the clerk. That is not going to go over well. If there's no other option, sure, but we have people who are coming in from out of state, for example, people who are elderly, people who may have been exposed or are still, for example, may have been exposed to COVID or the Delta variant, but are still healthy enough to testify. They're not showing any signs. Maybe they've tested negative, things like that. What I did note is, and what tends to win almost every time, if you're not, if someone has been exposed and they go into the courtroom and they have not tested negative or had a test, you should make sure that your client has tested negative just as additional assurance. For example, we had a trial earlier this year, a client had COVID and survived, and it was not a terrible case, but he had it. And I said, look, going the Thursday before his trial started, Monday, so I need you to go get a COVID test. And he was grousing and he showed them to me. And, I did not want the trial continued because the other side was trying to do that. So I was concerned that he's had COVID. He's not been fully vaccinated yet. They weren't going to stop the trial. I think that tends to play pretty well. I mean, it's not going to win your case, but there is this sense, at least in the courtrooms I've been in, that people need to be responsible when they're in the courtroom. And part of being responsible is if you've been exposed, get tested. If you're vaccinated, they wear masks, be respectful of people's personal space and things like that. So again, that is something to be aware of. But again, if you're arranging for someone to come in remotely, confer with opposing counsel well ahead of time, get their clerk on the phone. There's the issue of the ex parte communication, and make sure that the clerk understands so that the judge understands and reasonably knows what to expect when they come in for the first day of trial. And that kind of planning and thinking about is the judge hearing about this for the first time? Are there going to be surprises? Things like that, I think really goes a long way and can be very effective in your presentation, because you're already establishing yourself as someone who's behaving ethically, you're behaving responsibly, and you thought about the court. You're separating, you're distinguishing yourself from some other attorneys. Again, not knocking anybody who come in and just show up and go, Judge, this is your problem. You're supposed to help us, and that's, and again, I'm not going to speak for a superior, federal, or appellate court, any judge actually, but I can guarantee you that they aren't going to like that. If you show up prepared and present your case and don't dump on a judge, you're going to be in much better. Even if you don't win, you're going to be in much better shape. They're going to respect your professionalism, and you're going to be able to do that. We've had a jury trial up in Alameda County last year in October. It was the Honey Point case. It was a mesothelioma case. It wound up being a defense verdict. And I know some of you, it's in the materials. I would really, if you're interested in some of the issues that came up in that case where they were dealing with jurors, there's the issue of, can you really seat a remote jury? In LA, we're having difficulty seating any jurors because no one wants to go there, and they're pushing for this. We have 12 jurors here. They're pushing for the, state, in the state court, you're not required to get a unanimous verdict. In federal court, you are. And it's, I know, but they had remote jurors there. And there's a good article in your materials that talks about some of the issues that came up. One was keeping a juror interested, because when you have a juror in the courtroom, there's nothing else to look at. They can see your whole body. If you're fidgeting, if you're looking around, as you probably saw, my cat walked across the screen. They're doing things like that. Pet care was one of the ones that was stated there. Being interrupted by, your kids running around or things like that, or maybe the TV, maybe the game is on. Maybe the Dodger game's on, or maybe depending who you root for, the Yankee game is on or thing. I know they just had a series with the Red Sox. So again, you have all these being at home is more comfortable, but is it better as a juror to keep them from, jurors drift off anyways. They don't always pay attention, but if they're at home, I can guarantee you not. There's the issue of also discussing the case. The judge had tried to put them in breakout rooms specifically to discuss that. They were supposed to be separated. Are they really having contact or not? Is anybody else hearing the trial that shouldn't be there? Maybe a child or a witness or anybody like that. So there were some issues about that. And I think the other issue they talked about was, are you going to get as high a verdict if you're a plaintiff's attorney if you have a remote trial? And I think what Josh is saying is, I don't think you would. And I think I tend to agree with that based on the experiences here. And again, in our materials is an article about that we think the verdicts will be lower and the judgments will be lower, even if it's a bench trial. I know that one of the reasons that the trial I mentioned last spring was in person it was a quasi one, but we went in and the judge, it was a bench trial. The judge didn't hit our client. We got a defense verdict, but another party got over $200,000 in sanctions, less than $60,000 in damages. So, again, they will do that, but I don't think that he would have got that if he was not in person. And there is this feeling that if you have a case that's really important and there's a big option for damages, things like that, maybe you do need to be in person. And maybe to see that, and like, again, for example, one trial we had, I have one client is a victim, and it's very persuasive to see her because she's visibly shaken. You can see her. The other client, very charming guy. I mean, he's just like that anyway. So to see him joke, you don't get to joke around with the bailiff and the clerk if you're not there. Not that but there are professional limits, but he's definitely like that. And he was very social, walking around and see, there's always that one where the doors fly open in the courtroom. Someone walks into the courtroom. Who is it? You're not going to have any of that in a virtual trial. If you do, the judge going, who is that in the background, please? I know you're not a cat, but I think, again, you got to prepare on these. You really, really do. Being prepared is probably more important because on Zoom, when you're in the courtroom, you can probably say, okay, you can stall. Let's face facts. There's ways to get things in and go, hey, you're not going to have any of that in Zoom. They're like, hey, we're waiting here on camera. What are you guys doing? Counsel, where's your first witness? And, the people who are in person, someone's charming or cute, or there's other physical ways you can handle a trial. you've got to be prepared with Zoom trials. You got to have your exhibits. You should have them ahead of time. You should have talked to counsel several times. If they don't do anything, I've had situations in contested hearings where we just brief it and they'll like send one over. You know, again, California, depending on what court you are in, they have very clear rules about what is considered ex parte contact. The Bay Area, for example, is a lot more stringent than LA. But if you're dropping things off at the judge's department and you have not talked to opposing counsel because you think that, you know, what used to fly 20 or 30 years ago, that courtesy copy to the judge is okay, it may not be okay. There are people who have gotten in ethical trouble in the state of California. You are much better off contacting opposing counsel and say, hey, I'm going to submit this. Why don't we agree to submit jointly? Let's have someone, your office can call, my office can call. Do they want an email copy? Do they want a hard copy? What do they want? And find that out. Once in a while, I have found, to my surprise, that we've had some opposing counselors not very cooperative with that. But you're much better off, at least, again, in California, and as I'm learning in New York, to contact them and find out, because that contact could be construed as an ex parte communication. I know that I've conferred with some ethics attorneys in presentations, and they have stated that they're representing people in state bar defense claims because the mere act of going over and presenting those documents. So please be very, very careful about that. And again, I think going forward, and just know, make sure you have the technology. Please, please, please be prepared. And you should have, I think everybody also is saying here, what I'm hearing and I agree with, as I sit in front of 2 computers and an extra one on the floor, is please be prepared and be prepared for something to go wrong, because invariably it will anyways. As we know in trial, when we prep a witness, we say, okay, look, if this happens, it's all right. We're going to do this. You know, there's, you know, because a witness, you know, sometimes witnesses are terrified that they're going to say something wrong and fire and brimstone is going to come down. They're going to lose their case. So the reality is, unless they say I took an axe and killed this person, it's probably not true, but they don't know that. So there's always preparing for backups and what I call backups and contingencies. And you've got to do this. If you do these, you're going to be very, very prepared. And again, I know that being in person is important. I had an administrative trial last year, which was all remote. And our client, who was a victim, actually felt very comfortable testifying remotely because she was traumatized and she was afraid of the other party. And she was afraid to confront him. And she made it through. A few times I didn't think she was going to, but she really was strong about it. But you know, there is the in-person presence, but I think for some people who are really fearful of going into court and confronting a person may have physically harmed them, or may have abused them, or may have taken advantage of them, or it's just a financial bully. You know, there's a lot of, I've talked to a lot of, you know, I'm fine being on thing because I'm not in the room with them. I have to see them, but I don't have to be near them. I can't actually, he can't physically, he or she can't physically touch me. I can't smell them. I can't see what they're, you know, most of what they're doing, because you're usually, at most, you're talking from mid-torso up where you're looking. So there are some real advantages for certain situations about the virtual trial. So I would really think about that. And, you know, again, we've all dealt with bullies. We've all dealt with opposing party who's a bully. And it can really help some people, you know, find the courage to, you know, be able to testify in what are very tense situations. So, guys, I'd be interested in hearing everybody else's thoughts about that. Mari, I know that you've had done a lot of court work too. What are your thoughts here?
I think all the points that you made about being prepared, planning ahead, all of that is totally on point. And I do think too that this is something that's going to continue into the future, at least in some jurisdictions, and also in particular cases like what you mentioned. And so, you know, I think it's something that we're all going to continue to get better at also as time goes on and find more efficient ways to do it.
And David, what are your thoughts?
Well, where I have had some experience in this area is really with arbitrations. And the arbitrators are very eager to do their trials remotely. And I think they have worked extremely efficiently. And I don't know of any in-person arbitration that's taken place And it just goes to show that they've adapted extremely well to it. And I haven't even heard any complaints about virtual arbitrations as being deficient in any way. So I think that is a reality now, and will to some degree continue in the future. I know that in arbitrations that I've had, virtual witnesses were a very commonplace thing. So now it's just expanding that to the entire trial.
And Dan, how do you feel about these?
Yeah, well, I spoke with the LA Superior Court judge who's actually in the middle of a jury trial right now, and it's sort of a hybrid between in-person and remote. So the jurors are there and they're in masks, and some witnesses are testifying remotely, and the lawyers seem to be mostly present. And the two bits of advice that he provided, other than make sure your witness is wearing pants, is to test your remote feed, make sure it's stable, make sure your witness's feed is stable. You don't want to be wasting anyone's time with technological issues. And also think ahead of time as how you're going to show a witness a document that you want to be admitted into evidence before it's admitted, because you can't show the jury a document that has not been admitted yet. So think ahead of time, plan ahead of time. How are you going to do this? How are you going to have the witness authenticate something before the jury sees it? And finally, the jurors are in masks. They're sitting there in the courtroom. The courtroom staff are in masks. Be considerate, extra considerate of their time. I know as trial lawyers, making sure the jurors are comfortable and know that we're cognizant and considerate of their time. In a normal situation, that's a concern of ours. But in here, when they're in masks, they're probably uncomfortable being in the courtroom. Be as efficient as you can. And this is what that judge said. Be efficient. Faster is better, in COVID more so than ever.
Gabriel, what are your thoughts here? And I know that some of us have talked to judges too, which is the next area we're going to move into, which Dan has already led us into. But I know everybody wants to think about what judges want, because what they're doing and what they're saying. Gabriel, what are your thoughts here?
Yeah, my reaction is that, all of what you were saying, Hillary, about what you're seeing from an advocate's perspective, the judges are seeing from the other side, and the efficiency gains, and this, the lawyers coming in more prepared, not being able to sort of have too many antics at work. I think those are all going to drive toward an interest on the part of the judges to try to maintain some of this going forward. And so I do think, I think there's obviously certain kinds of things, certain kinds of criminal cases and civil cases that just won't be remote and can't be remote. But I do think there will be a real interest in which ones can be, and trying to find those and trying to keep them moving forward. Because I think if you talk to any judges, like they're all strapped for time, and they're always wishing they could move their cases more quickly. And so I do think that this is going to be a question of how much, and not if yes or if no, but I think just which parts of this is going to keep going forward.
Yeah, and just to piggyback on that, I think judges, at least in LA, and I'm sure in New York too, there's such a backlog of cases that they're wanting to try in any way that they could clear the backlog. If it's doing things remotely or hybrid or whatever, they're just really eager to get things moving along. Obviously lawyers as well, but the judges, it makes them very tense, I think, having that backlog.
Well, if they're having trials at all, I think the one we had last spring, I asked if they'd had any others. They said we had one trial within the last 12 months, they'd had one trial. That was it. So they're not, maybe they're a lot are probably settling or going to ADR, but a lot are just getting put out. There's judges downtown in LA are just saying, oh, you're not getting a trial this year. Yeah, that's not going to happen. I know it's on calendar, but it's not going to happen. So this is the direct, at least currently, the direction we're headed. Josh, how do you feel about what are your insights here about what judges want?
I think two things. First, Hillary, you and I were both talking about whether it would be desirable to try a heavy case in person now with all the COVID restrictions. I talked to a judge who is a New York trial level judge who had presided over a couple of these trials in person. And he said if it were him, he wouldn't want to try a heavy case this way either, because he thinks that the precautions are a distraction and it makes it harder for the jurors to really connect with the case and the witness the way they otherwise would. But otherwise, I think what everybody is saying, what judges want is civility. And they always want that, but it's particularly clear here because if the parties aren't cooperating on remote issues, on technology issues, on other kinds of issues that are unique to the virtual context, it can grind things to a halt in a way that is that much more distracting and annoying to the judge. So civility is a good way to practice in general, and it's particularly important now.
I think there's also the additional point of, I felt very uncomfortable sitting in a trial. I had not been, I was not happy. I was not happy to be there, and I love trials. But I hadn't been vaccinated. I just became eligible. There was a wait, we were down to, I think after were submitted on the plea, the rest was submitted. I went to Dodger Stadium a couple days later and got vaccinated. But, it's even being vaccinated, going to the courtroom on a limited basis. I've been doing, I don't know how everyone else feels. I'm not real comfortable with that. I don't know who's been vaccinated. I don't know who isn't. I don't know if people are carriers, and again, normally it was totally fine. Okay, we go on, we have our roll call or our cattle call, whatever you want to call it. And particularly, but now everything's done remotely and most people aren't even in the courtroom. I mean, I know it was kind of like looking at a vacating building, when you go down there, it used to be lines out the door every morning, and it's not that situation anymore. It really is a different feeling. I don't know. How does everybody else feel? Mari, what's your feeling?
Yeah, the things that I've heard to your question about what judges want, I think that two are to be efficient and to figure out your own problems. So the first is, don't, for example, go on a letter writing campaign on a discovery issue if the judge has already communicated either in their rules or elsewhere that they're not going to take a look at any discovery letters, look at the rules or call chambers to see what the best way is to raise a dispute. So that's the first thing. And then the second one is, to the extent that you can resolve issues between the parties, do everything you can to do it, because the threshold for what is important right now, or what can warrant a sufficient time from a judge is very high. And so I've seen that too communicated in a number of different ways. That basically, I don't want to hear about this issue if it's something I think you could have figured out on your own.
I think there's definitely that. And I in preparation for today, and I was asked by the Honorable Appellate Justice Robert Cohen of Pennsylvania, who is we have mutual friends. I talked to him about what he's seen. He says, well, I'm an appellate judge, but he said to mention, he goes, I don't have a lot of work right now because there's no criminal cases. So half my caseload is criminal ones, and they're not doing that. So, he thinks there's going to be the Sixth Amendment issue and things like that. It'll probably go to the Supreme Court. That's his opinion. But he also said, the appellate judges aren't real busy right now, because that was our job to have these cases to go to trial that they would look at. And I thought, I don't do much appellate work, but I thought it was an interesting perspective. I'm curious, where does everybody see us going in the future with these? I know we've touched upon it here, but how do you think this pandemic, assuming there's not another one and there's signs from the DOJ and DOD, or there may be others, which again, I'm knocking on wood, it says won't be. How has this pandemic shaped your law practice, and what do you think we can reasonably expect to see in the future? Mari, what do you think?
That's a good question. I do think that it's shifted the way we communicate with our clients, the way we communicate with courts, the way we communicate with each other. And I do think, and I know we've touched on this already, I do think a lot of that is here to stay. I do think that, both our informal communications, for example, video conferencing. I never used video conference before the pandemic. I hated it. And now I use it a lot, and I'll probably continue to use it even when, we go back to in person. And I think on the, hearing trials, depositions, I think we will continue to use it more frequently there than we have in the past too. So I do think it will make things more interconnected in a way that, we wouldn't have before.
I would agree. I always thought it was sort of pretentious when I'd see these people on video calls. I'd like, oh, and now I assume like, oh yeah, everybody does now. David, what do you think?
Well, on depositions, I think they're here to stay. On mediation and arbitration, I think somewhat, because I still think people want to connect with the mediator and want the mediator to connect with the other side. And arbitration, I think the same thing. People want to be face-to-face and addressing the kinds of things that Josh was talking about with connecting. with trials in court, I sure hope that they are going to start entertaining virtual witnesses. And I think that that's a possibility. I can see the courts wanting to do that. And as far as hearings go, I can remember, we've always had court call. We've had court call for a very long time, where you can participate in a hearing by telephone. But I can remember never wanting to do that because the judges seem to have this exaggerated eye roll while the person who was delivering their argument over the telephone was trying to get their point across, and the judge seemed to be communicating that what's the problem? It wasn't important enough for you to come down here. Now, I think it's exactly the opposite. The courts don't want you around, and I sure hope that they keep this private virtual network because it seems to be just fine, and in so many of the oral arguments, perfectly appropriate.
David, I would echo that. The judge who I spoke with said exactly the same thing. He said it's a myth that appearing remotely does a client a disservice. I want lawyers to appear remotely because I don't want 30 lawyers in my courtroom, possibly like infecting my staff. And this is so encouraging remote appearances. I had the same issues you had where I thought that if it doesn't matter enough to me to appear there in person, the judge is not going to give me the time or attention that I think the case deserves. But this judge really tried to dissuade me of that notion. And I think it's because of what we're going through.
I think we can all remember times we've been in courtrooms, you've seen someone on court call and they don't see the court, so they're not reading the signs, they're not reading the visuals of the judge going, this isn't the time you shut up. So,
and another thing just to mention too, Hillary, is the judge can't possibly understand what you're saying if you've got your mask on. And if you're there in person, she's not going to maybe be able to understand you as well if you're appearing remotely. And that's something to consider too. Maybe you're actually doing your clients a disservice by being there in person where the judge can't possibly understand you as well.
I actually had a microphone during one of the trials because I had one of those 95 masks on, and it was hard to project that far across the courtroom. So it was very nice. They actually said we've brought these to a lot of people, and they brought me over a microphone, which I've not ever used. I was thinking I was like in a karaoke bar. Gabriel, how do you feel about this? What do you think? What do you see happening?
Yeah, sort of dovetailing on what Mari said, I kind of envision a real shift in the practice of law. So focusing a little less on depositions and hearings, I think, the way we interact, the sort of our ability to communicate, like selfishly, like I'm looking forward to a more hybrid model. And I have a young son and I'd like to sort of spend more time physically with him. But I also think there's a lot of work right now being written about how a more hybrid and remote model of work can affect and enhance the experiences of marginalized people and really bring more people into the practice of law and into workplaces that wouldn't necessarily have been able to access it because of, issues around the difficulty of commute for someone living with a particular kind of disability, people with children. And so I do think that there's like a world in which we can imagine a new way of practicing law that also gives more people access to the practice of law, and also allows us to engage with each other when we're in so many disparate places. And I think that's something that's encouraging. I'm excited to sort of see how all of our practices evolve in the next few years with this, new lens.
Josh, what do you think?
First, that's a great point that Gabe made, and it's something that I haven't heard people say on other panels, and it's a great insight, and I hope that it proves true. I guess just two major things that I would say is first, in New York, in a lot of our state courts in very busy counties, it's been customary for there to be parts with 100 cases all on at once, all scheduled for 9:30 in the morning. And then you'll all wait your turn in line to see the court attorney when you hand in an order that you could have agreed to in advance. Our court rules were recently amended to encourage courts like that to have staggered appearances where each case gets its own 5 or 10 or 15-minute block. And I think that that's been in part a product of COVID, where I think courts will tend away from those busy cattle call parts and have more either staggered appearances or opportunities to submit orders in those cases in advance. And then second, I think Gabe and Mari are absolutely right that you're going to see more remote work as a feature of a law practice. But with remote work, I think it becomes a challenge to make sure that you're still collaborating. Because when we all work from home and we're not in physical proximity to each other, you run the risk that you're practicing as an island unto yourself. And so how do you make sure that you're still talking to your colleagues, that you're still bouncing things off of people and getting the benefit of a variety of insights? I mean, I think what it becomes is more of just a conscious choice of making sure that you know what you don't know, that you're not too overly confident or overly impressed with your own insights, and that you know that it's a good thing to reach out, even if you like what you're doing, because other people always have perspectives they can bring to bear that will make the work product better. I mean, I think that that's something that all of us need to be more actively conscious of when we're working remotely, because it won't happen just by default from walking down a hallway or going to lunch.
And lest we forget, one of the reasons we're here, if you're not a government attorney, is what about our clients? What are you seeing from your clients? With the pandemic, in trial situations, or what could be trial situations, litigation going into trial, and what are you doing to manage them and to represent them well? Because I'm getting anything from great, it's being put out, great, put it out as far as you can. Don't worry about me. To I want to be in trial tomorrow, and why can't you do this for me? And the phone calls and getting upset. Josh, what are you seeing?
I mean, you're absolutely right. Like, I've had some version of the conversation of explaining COVID delays to clients, and some are very understanding of it, and some are intellectually aware of it, but it's still, for someone who is struggling to make ends meet and can't work because of an injury, it's small solace to say to them, well, but COVID is slowing down your case. And so I think some of it is just being aware of your client's unique challenges and finding ways to push cases forward as a priority if a client has a unique and exigent need. But you're right, it's a constant challenge.
And Mari, what are you seeing?
Yeah, I think that's right. I mean, even before COVID, there's a variety of reasons why cases get delayed. So I guess I kind of view the COVID delays as in line with many of those things, and needing to explain to people why things take longer and why magically sometimes things go faster, and trying to be a little bit more creative about finding ways to push cases along or try to read the tea leaves. But I have to say, like, reading the tea leaves these days is very challenging, I find. And so I think, before it was difficult to gauge timing on a lot of things. Now I find it nearly impossible. And I would say clients actually understand that, because it's like an added level of uncertainty. And so, at least for us, working primarily with corporate clients, they do understand that.
There is the commonality where it's not just an excuse, it really is true. And you can sort of, everybody's been affected by this. Gabriel, what are your thoughts?
I was just going to say essentially that I think that we're, in some sense, we're just getting a little closer to our clients. I think I've been on more Zoom calls with my clients than I ever had in the past. And I think being able to be there with them and sort of live through this with them has made it a lot easier to communicate around these kinds of things. And they really, I think, just as it's sort of on the sort of counterparty side, it increased the civility. I think it's also just increased the connectivity with the clients in some ways.
Dan, how do you feel about this?
Well, I think it depends if you're representing plaintiffs or defendants, right? So most plaintiffs are more eager to get their case resolved, and because they're like Josh was saying, they're relying on the expectation of some sort of compensation. And my practice is mostly defense work, and they're happy to kick things down the road and drag the plaintiff along, because maybe that will aid in their settlement position.
So for that one who's got to clear his or her name and wants to go to trial now. David.
Well, I represent mostly plaintiffs who get cheated in business and securities transactions, and they've suffered the financial losses, usually quite a time in the distant past from before we even file. And so it's very difficult. It's very difficult to explain to them what's going on and how the other side is only a very small part of what I'm worried about with their case. that the other side I can take care of. It's the courts and the system that I can't deal with. I can't deal with delayed hearings and constant continuances. And I can deal great with Dan Lapidus, but that position of, hey, we're happy, we'll just kick this out until, the next century. And the settlements, there's no real reason to make a reasonable settlement offer when you've got no real fear that you're going to trial anytime soon. So
I would also add too that at least in Los Angeles, the trial date that you have is not necessarily the trial date you're going to have. You could have, I've got trials set for October, November, December, and I have no expectation that those trials are going forward. So it's difficult for planning. It's difficult for client expectations, and lawyers, we're lawyers and we're therapists, and we've got a lot of balls that we juggle in the air with our clients, and I think that just adds to it.
I would agree too. Does anyone have any parting words that they would like to share, advice for our viewers other than what we've discussed? Dan, since you're on already.
No, look, this has been a challenge for everyone, and I would just implore people to be, considerate and compassionate to everyone in your profession. Your adversaries are just your litigation adversaries and not your life adversaries. And just be kind and practice patience. And we're all in this together. And work on things with your opposing counsel, and talk to your judges. I'm impressed with how reasonable and they've been with our time, and vice versa. Be kind.
David?
I would say that I think the silver lining is that we are going to change the way we deal with each other, that a better practice of law is going to emerge from this. But I think it's the Grateful Dead that said every silver lining has a touch of gray. And I think that's what we're living with.
And Maury?
I would echo what both Daniel and David said. I agree with all of it. And part of the silver lining has showed up in my hair that I can see on the screen. But those were very wise words. Nothing to add there.
Hey, Gabriel?
It's been in my beard. I think the only thing I'll say is just lean in. I think we're heading somewhere with technology and with our practice of law. And I think, we need to lean into it. We need to understand the technology, and we need to embrace the changes that are coming, because that's, going back to the ethics part that Dan and I were discussing, that's a part of what it means to be a competent lawyer. And so, we all need to be, we're all learning it together, but we all need to kind of keep learning it and keep leaning forward in it.
And Josh?
Yeah, I think Dan said it better than I ever could. Just that now more than ever, it's important to practice with kindness and respect and consideration for each other. And Hillary, I think it's only fair. We would love to hear what you have to say on the issue.
Oh, thanks. I agree with Mari. I have a few more gray hairs. I'm firmly convinced it's due to the pandemic. That's the story I'm going with. I want to be clear. You heard it here today. This has been hard for everybody, but I think there's some good that's come out of this. I think technology and efficiency, they sound like very sterile ideas, very cold and sterile, but there's a good in that. And I think what I have seen is we've seen some junk cases. We do a lot of defense work, but I am seeing a lot less nuisance cases. There's been a few of them, but it seems like people are doing that. And I kind of like what I see with the judges, where they're not putting up with, and maybe it's because I do defense work. Maybe I have a bias, and I'm sure I do. But I like seeing that judges aren't putting up, because sometimes we've all been in court where we're going, oh, I'm never going to get out of here. It's just all day, and and it's over nothing. There's nothing really happened during the day, and you're like, what exactly did we accomplish? So I see a lot less of that. So I think maybe we can see higher standards of professionalism for everybody. And some people are going to do things because they have to, and some people are going to do things because they want to. And I think the better part of civility is whether it's because they know they have to and they're not going to get away with it anymore, or because they had those standards before and it's now easier to do. I'm really glad to see that. And glad to see all of you. This was a really fun and I think really informative presentation. And I know that we covered a lot of ground, but I think that these are all issues that we're dealing with as litigators and trial lawyers. I want to thank all of you so much for coming. And I know Barry has a few things to tell our audience, but thank you.
I want to thank everybody and thank everybody for participating and staying, and thank you for your questions. And again, be sure to be on the lookout for your email next week for where you're going to download your CLE certificates. And we want to thank all of our speakers, and I especially want to thank you, Hillary, and Rudy, your co-chair, for putting this together.